Well, who are trying to help you, our viewers, to understand what exactly does this ruling now mean. But before we do that, while the legal process of contesting a presidential election may appear quite streamlined, it wasn't always the case. The grave losers of the elections had to deal with a broken system and an aggressive regime just to get their petitions heard. Here's Asha Mwilo with a breakdown of the petitions from the 90s.
The rough journey through presidential election petitions dates back to early 1993, when veteran politician Kenneth Matiba moved to the High Court to challenge retired President Daniel Toroitich Arap Moi's win in the first Kenyan multi-party elections of 1992. In the petition, Matiba accused Moi of rigging the elections and instigating ethnic violence, particularly in the Rift Valley, as a scheme to intimidate and lock out Matiba's supporters from the polls. But Matiba suffered a stroke that paralyzed both of his arms following months of detention and torture. He couldn't sign the court papers. His wife signed the petition on his behalf. On this basis, Justice Riaga Omolo dismissed the Matiba petition. But the verdict would years later come to haunt the judge and cost him his job. In early 2012, the Judges and Magistrates Vetting Board found Justice Omolo unfit to serve on grounds that the Matiba ruling had demonstrated his disrespect for the disabled. But the judiciary was yet again on the spot after the second multi-party elections of 1997. This time, then Democratic Party presidential candidate, retired President Mwai Kibaki, was challenging Moi's re-election. To notify Moi and the Electoral Commission of his intention to go to court, Kibaki published notice of his petition on the official Kenya Gazette. But he was in for a rude shock. A three-judge bench comprising Justices Emmanuel Kubasu, Msaga Mbogoli, and Moijo Olekeiwa struck out the petition on the basis that Kibaki's lawyers had not physically served President Moi with the court papers.
I'm the longest-serving judge in this republic.
But this verdict would in the year 2016 come to haunt Justice Mbogoli, who had applied for the Chief Justice job.
Kibaki and Moi, which of course you've been asked about, and which decision you seem to regret. Do you regret the decision?
That was a three-judge decision. And when you conference, when you retire to chambers and you conference, you may not have a voice, even if it's a dissenting voice, in a ruling of that nature. I'm not saying that I had a contrary decision from my colleagues who are there, but that one did not cross our mind at that time about substantive justice under that article of the current constitution.
But arguably the most memorable presidential election petition was that filed by opposition leader Raila Odinga at the Supreme Court in 2013, challenging the election of President Uhuru Kenyatta. After the constitutionally mandated 14 days hearing the petition, a 6-judge bench chaired by retired Chief Justice Dr. Willy Mutunga unanimously upheld Kenyatta's election.
The manner in which the court handled that petition was a travesty of justice. The court decided all interim applications in favor of Mr. Kenyatta.
David Kenani Maraga.
The spotlight now turns to the current Supreme Court bench, chaired by Chief Justice David Maraga, as Odinga prepares to file his petition against Kenyatta's re-election. Murimi Mwangi, KTN News, Nairobi.
Murimi Mwangi there, looking at the history of presidential petitions. And just when you look at that story by Murimi Mwangi, you understand why the ruling today by the Supreme Court is huge, is fundamental. So in studio, like I mentioned, you have Martin Olo and you have Charles Kanjama. Martin, what exactly, from where you sit, because you've looked at the history of presidential petitions and Raila at some point being part of them, what does this mean for Raila today, the ruling by the Supreme Court?
I think it's less of Raila than just for us as Kenyans to believe that we've come a long way where if you challenge the incumbent president, it depended, I mean, whether you did very well or not,
Yeah.
even if you had a complaint against them, you could not reach them.
Yeah,
That
like
is,
someone was told you did not
could not
personally
serve. And at that time, we had such bad law that required personal service. So we've since moved and said, look, you can serve, we have substituted service or petitions, even through newspapers and so on. Because those days you could go, all I needed to do is lock my gate, disappear, you cannot find me, and I surfaced after the hours. Remember, those were also the good days when nominations ended at a certain time. So as you were going for nominations, you could be abducted on the way, people disappear you, and you resurface after the 12 o'clock. So there were other mechanisms that were not very friendly. We've come a long way, and what we are saying is this, that for me, again, from a jurisprudence perspective, after the 2010 Constitution, I think that we have witnessed at least a breaking ground by the Supreme Court. Granted, the first decision in 2013 had its own limbs, it had its own challenges, and perhaps it did not help us. And maybe the only excuse one can have now is that that was our first Supreme Court decision, and we had 7 days. Remember, these guys have, this particular Supreme Court has had 14 days, which is something that was added after the experience of the 2013
one.
Yeah, because in 2013 they had 7 days. So in a hurry, they just stepped all over the place. These particular guys had a little bit of time, and then they had learned something.
Is that time sufficient still, or do we need
to? It's still not sufficient. That's why I'm thinking that we should look at our constitution. Look at the volume, 70,000 pages to plow through within 14 days.
And Maraga says
it's not humanly possible.
It was tons and tons of...
Again, in my view, we must go back and look at this thing and say, is this the best thing we can do for ourselves? Why are we in a hurry? Look at the US. You vote in November, and the president is sworn in January. You create enough room for any of these things to happen, petitions and whatnot. So why don't we create time for ourselves and at least make sure that the human beings that we put in the Supreme Court can actually have time to administer some of these issues and listen to some of the challenges that come through. So for me, we are at a good place with this ruling, particularly when you look forward. I think we were going to be so bottled up. If 2013, you had a complaint, nobody listened to you. 2017, you have a complaint, you have evidence, nobody's listening to you. By the time we would have gotten 2017, maybe, who knows?
2022.
Rather, 2022, yeah. We would have been in a different place. I have had people who have said that I'll never vote again. I'm sure this takes them back to the ballot.
Yeah.
And so there is a bit of hope for us. So it's a bit of renewal of ourselves and just giving ourselves more hope, but also contributing to democratic gains and deepening the kind of processes that we need in order to be a people. Today they say, look, we made ourselves a constitution. Let us be faithful to that constitution. Today they have said that it's in that order. There's a constitution, then the law. You cannot cite, and unfortunately I saw some of my very, very senior colleagues in the Supreme Court busy ventilating issues on the law when actually some of those legal, statutory issues were contradicting or was being superseded or being at least contradicted by the constitutional provisions.
Yeah. Kanjama, in terms of democracy, in terms of the rule of law, in terms of jurisprudence, what does this now mean?
I think, Linda, it is widely accepted that democracy is not just about casting your vote. It's about the institutions that safeguard the vote. It's about the institutions that are set up to govern the country pursuant to that democratic process, parliament, the judiciary, and so on. And so definitely when other institutions flex their muscles and therefore try to create more checks and balances in the country, it is good for the country. So I'm talking about it from just the principle perspective. The fact that judiciary is given the power to nullify elections, but none has ever done so, is not very positive, because people then start imagining, can we engage in all kinds of misconduct and the judiciary will never exercise its powers? You remember there was this distinction between de facto and de jure, that we, in the previous constitution of Kenya, we had a law that allowed multipartyism until 1982. But in actual fact, we never had a multi-party elections after independence, because in all the previous electoral cycles, the administrative mechanism would be brought to bear to stop any other party from offering candidates for election. So it is actually positive when the de jure positions or the positions in the law can be implemented and actuated. And I think overall it will create a greater sense of accuracy and need for competence among the electoral management body, even among politicians. I think this outcome says something about them, because just a few months ago we had very shambolic party primaries.
Yeah.
And many of those who came out of those party primaries actually were allowed to eventually contest the general election. So I think this decision will have ramifications that will go down even to the entire political infrastructure, and probably it's a new dawn for this country in terms of fidelity and adherence to the rule of law. We hope that whatever outcomes come out of this process will safeguard our new constitutional dispensation.
I just wanted to add something, that
Please.
the biggest lesson that this should also bring to us is that these parties and the party leaders should also hold credible primaries. It cannot be that your primaries are shambolic,
And then you
are an
expect
exercise
IEBC
in cheating and forgery, and you want to have a proper national election. So please, it must apply even in primaries.
For our viewers just joining us, we are showing you pictures on your screen of different celebrations around the country on that Supreme Court ruling that has now nullified Uhuru Kenyatta's win. Remember, Kenya went into an election on August 8th, and of course the IEBC ended up declaring Uhuru Kenyatta as duly elected in that particular election. The Supreme Court has now nullified Uhuru Kenyatta's win. So there are two things that we expect to happen any moment from now. IEBC Chair Wafula Chebukati is expected to give a presser any moment from now. We'll cross over and listen into what exactly he will want to tell the country just hours after the Supreme Court nullified Uhuru Kenyatta's win. And of course, he's the one who made that announcement at the Bomas of Kenya. That was the National Tallying Center 2. We expect President Uhuru Kenyatta to give an address to the entire nation in the next 1 hour. We have a team on the ground as well. So we'll cross over to the two, IBC Chair Wafula Chebukati and Uhuru Kenyatta, who's expected to give a presser in the next 1 hour. We'll cross over and just listen in a little bit to what they will both have to say. It would be interesting, though, to hear what Uhuru Kenyatta, the president, will have to say, will want to tell the Kenyans. And it would be interesting to hear what Wafula Chebukati will also want to tell the country. Remember, the Supreme Court has ordered the Independent Electoral and Boundaries Commission, who were the first respondents, to organize and conduct fresh elections in 60 days. So probably part of what Wafula Chebukati will have to say is probably what next for the country. So those are the two issues we are keeping an eye on for you. So like I mentioned, the Supreme Court has this morning nullified Uhuru Kenyatta's win. They said the presidential election held on the 8th was not conducted in accordance with the Constitution. They say the third respondent, that is Uhuru Kenyatta, was not validly declared as president-elect, and that declaration is invalid, and the first respondent, that is the IEBC, should conduct fresh elections in 60 days. Allow me to take a short break before we go on with this conversation and indeed the coverage that is of key importance to Kenyans. From now on, of course, we're going back to the ballot in 60 days.
Trying the mic, 1, 2, 1.